are my rights as a tenant and a landlord? Today we're discussing all about property and tenant and landlord obligations. Welcome to the Property Simplified show. I'm Claire Munde. To discuss this topic, we are joined by Erick Mukaye, who is the CEO of EMM Consult and a property manager. Now, let's talk about the lease agreement. What are some of the clauses that we should be looking out for before signing as tenants? Because sometimes we're in a rush to move into a house and then we move into the house and then we find, oh, there was a clause that we were not aware of. So what are some of the things that tenants miss in that tenancy agreement that we should be looking out for? Tenancy agreement.
Many of the things I realize is when a tenant is looking for a house, some of them are in a desperate state and probably have identified the property. They think this is what I want. So they are less careful to look at what the terms and conditions are when they're moving in. So they end up signing documents they have not even read. When they're moving out, they say, but I didn't see this. But you see, you signed. The simple things you need to look out for, one is the term. How much time you want to stay in that place? How much are you ready to pay? Is it inclusive of the service charge or is it just the rent? Because sometimes you sign, then you discover it was inclusive of service charge or not, so you have an extra amount to pay. So when you moved in, you're told, oh, you need to pay for the security. The security fellow refuses to open for you, or water was not provided for and all that. So look out, what does the rent include? What is the rent and what does it include and what does it exclude? Does it have garbage collection? Does it have security lighting? Does it have, water provision? All those things you must be careful about. The other thing that you need to be careful when you're signing an agreement is, what are the exit clauses should I choose to move out of this place before the expiry of that period? So you need to have an exit clause so that at the end of it, you're not saying there was no provision for me to give you notice, or I can use my security deposit as my last month's rent. In most cases, it is not. But because we don't read, somebody tells you, I'm moving out at the end of the month and I'm using my security. Then you begin to have conflict with the landlord. So what are the exit clauses you have? In case of default, that's the other point, what are the methods of recourse for both of you? If the tenant does not observe their end of bargain, what are the options the landlord has to exercise? Because there are legal ways in which that can be done. But because we don't read, and some landlords can always go around and do crazy things. So you need to know what is provided for in the agreement in case you default. As a tenant, something could happen and you're not able to pay on the first day. On the second day, the landlord arrives, locks your place. So what are the recourse you have as a tenant? And then for the landlord also, should the tenant not be able to pay, what can they do? And what can the tenant do if the landlord is not observing their end of bargain? For example, the landlord is not paying their service charge, yet it's included in the rent you're paying. As a tenant, what is the option you have to address that? Or the landlord is not meeting the obligation to maintain the structure of the building that is his part of the bargain. What do you have as a recourse as a tenant? Because you have a right to enjoy your stay on that property. For the time you're a tenant, it is your property. And therefore, you need to enjoy your stay there. And the landlord needs to make sure that you have a peaceable stay on the property. He cannot barge in any time. He cannot refuse to do what he needs to do, because then it compromises your peace at the property. Those are some of the things you need to look out for when you're doing the sale agreement, the lease agreement.
Okay.
Yes.
So there is a common complaint that a lot of tenants say that when they're leaving a house, they never get their deposit back. They say that sometimes a landlord charges 1 month, sometimes it's 2 months. It really depends on the landlord. But when they want to leave the house, getting back their money is such a tall order that many of them just abandon the whole process. So how, as a tenant, will I get back my money? What's the legal way of going about it as tenant?
Every transaction of tenancy and landlord has basic agreements when you begin. Now, when you begin the tenancy, there is an agreement that I will restore the property to its original condition, number one, or I give the authority to the landlord to restore the property to its original condition and deduct from my deposit. So there are those two instances. Whichever way, whatever is left of the deposit is refundable to the tenant. And that there are no two ways about it. So instances where landlords choose not to return, that's illegal, it's unfair. And the tenant has got a legal right to claim for whatever deposit that one is. However, as I said, when you're taking up a house, it is important to have an inventory done of the property so that at the end of the lease or the tenancy, there are no disagreements on what you found and what you did not find. So if something that was in good working order is destroyed, you need to have an estimate on how much it is to restore it. And it has to be a reasonable amount. You're not talking about extreme. It has to be a real and acceptable amount. And therefore, then the cost is deducted off the deposit, or the tenant chooses to pay that and has his deposit refunded back in full. Whether the landlord asks for 1 month deposit or 2 months deposit depends on what the agreement shall be. Because in some instances, some properties can be a little more difficult to restore, so you find 1 month deposit is not sufficient to cover for any unexpected. But if there are simple structures that 1 month deposit can cover, then that's acceptable. So it totally depends on what the two of them can agree on. 1 month or 2 months, that's fine.
Okay. Now you've brought up the issue of raising rent. What is the right way of raising rent? Is there a lawful way of going about it? Does the law stipulate that you can't raise rent, let's say, more than 5% or 10% per year? Or what is the way to go about it?
An agreement is an agreement. If I got into an agreement with my landlord and he tells me I would want you to increase my rent after 1 year, if I'm comfortable with it, I'll do that. However, increment of rents should also be based on actual market situations, preferably on the market situation, so that they are not arbitrarily done. Because sometimes they will hold you ransom, knowing that moving is a difficult thing. So at the end of that year, they just tell you, now I'm increasing by 20%. You have a right to say no to that increment because it's very arbitrary. What are the market forces in the prevailing economic situations at that particular time that you can reasonably increase rent by? But in most cases, rent is not increased within 1 year, say for a period of 12 months, unless there's an agreement in between to increase, because probably you got a rebate at the beginning. In most cases, it's not supposed to take less than 12 months. After 12 months, then you can renegotiate, especially if you have a lease that allows, or a tenancy that allows you to renegotiate a renewal. Then at that point, you can renegotiate an increment or even a decrement, whichever way. Commercial leases, which are more than 5 years, they go into 5 years, 3 months and above, in most cases have got a clause of review in the process, either after 1 year, after 2 years, after whatever number of period of years. So that one you know from the beginning as you sign that will increase by 5% every year or 10% every 2 years. So you have an agreement that begins, when you're beginning it, you know that this is how the situation will be. Okay. Yes.
Now let's talk about eviction. What is the lawful way of evicting a tenant? Say they have defaulted on rent for many months. You have talked to this tenant, they said they're going to pay, but they don't pay, and months are moving, you have no money to show for it, perhaps you have a mortgage. What is the legal way of evicting a tenant?
Issues about recovering rent arrears is a very tricky thing, especially in this country. Nobody can lock your house because you did not pay rent. It is not allowed. The legal systems and mechanisms within which a landlord can seek redress when there's a default. One of which is, first, he must give you the first notice, probably after 7 days. After 14 days, he gives you another notice. And then after probably the second notice, then he has the option to seek the legal means of recovering any rent arrears. In most cases, you're supposed to ask the auctioneers to levy distress for recovery of unpaid rent. Auctioneers have got the Auctioneers Act, which stipulates what they can do and what they cannot do. So once it has come off your ambit to the auctioneers' hands, the auctioneers ought to professionally execute the process of recovering rent for you. And it stipulates, first they must come for proclamation. That means they come and list all the properties they think they can sell and recover money from. Then they come and attach if you don't pay within 10 days. Then they give you another 20 or 30 days to be able to pay if you don't. Then they can advertise for auction. So it's a lengthy process. It's not short. And within that period, if a tenant is serious and is able to, he should be able to redeem and pay, unless they have just become unable to or just incorrigible. Now, the actions that the auctioneers do to recover are fully covered for in the Auctioneers Act, and they are responsible under their body of regulation. Now, you cannot evict a tenant also unless you have got an eviction order. There's no landlord who can just come in and throw you out because you have not paid your rent. There is a process within which he needs to seek redress, and part of which is to go to court to get an eviction order. Upon getting an eviction order from court, he needs to go to the police to be able to give him reinforcements to come and evict. So it's a process that is fully covered, and it cannot happen arbitrarily the way people just imagine it can. So it is difficult. It's a difficult process trying to recover a rent arrears. In most cases, the best is to negotiate. The unfortunate thing is landlords are finding themselves enslaved because the law changed. Previously, it used to be quite easy because an auctioneer would come and they would harass you and bring all the goons and get your way. But it no longer happens. And the tenants have a right to refuse. You can go to court if somebody did that to you. Yes.
Thank you so much. We have been talking to Erick Mukaye, who is the CEO of EMM Consult, and he has shared with us all we need to look out for as tenants and landlords when we're getting into this all-important relationship of a tenancy agreement. Now, until next time, this has been the Property Simplified show. I have been your host, Claire Munde. Have a good week ahead.